Now, the Supreme Court of Nigeria last Monday affirmed the constitutional power of the president to declare a state of emergency in any state to prevent a breakdown of law and order or a descent into chaos and anarchy. In a decision of 6-1, the Apex Court justices upheld the president's authority under the Constitution to proclaim a state of emergency. There have been several interpretations of the Supreme Court's position on this matter, including one that claims that the President of Nigeria is now constitutionally empowered to suspend elected officials provided any such suspension is for a limited duration. Legal powerhouses in Nigeria have been reacting to this development, including Femi Falana, senior advocate of Nigeria, who has argued that the Supreme Court did not endorse this dissolution of democratic structures during emergency rule in any state of the Federation. Onyekachi Ubani, senior advocate of Nigeria, held that the ruling affirms a security-conscious and pragmatic interpretation of presidential emergency powers while articulating constitutional guardrails against abuse. In the meantime, the Nigerian government has enacted a comprehensive overhaul of its tax system through the 2025 Tax Reform Act, which consolidate multiple laws and introduce significant changes. And right now, joining me to discuss these matters is A.J. Owonikuku, Abiodun Jelili Owonikuku, senior advocate of Nigeria, who is a principal partner at Lagos law firm Synergy Attorneys. He joins me now to share his learned view on Supreme Court of Nigeria's position on powers of the president to impose a state of emergency and other matters. Thank you very much, A.J. Owonikuku, SAN, for joining us on the program.
Good afternoon, Dr. Abati.
Good afternoon. Thank you.
Good tidings of the Christmas season to all Nigerians.
Yeah, thank you very much indeed.
Always to be with you.
Thank you. Well,
yes, sir. Thank you.
The substantive issue, the main issue, is AG Adamawa and 10 others versus AG Federation and another. And the, what will be historic watershed decision of their lordships at the Supreme Court on Monday, and their decision that, yes, the president has powers under Section 305, and also that, he can exercise discretion, because Section 305, at Section 305 sub 5 and sub 3, I think, sub 4, talks about extraordinary measures, and that Constitution gives him, some leeway to exercise discretion. But first, I'd like you to help us do a judicial review of that majority decision.
Thank you, Doctor. It's heartwarming to note that this controversy that has lasted upwards of about 6-7 months since the official declaration of emergency in Rivers State in March has now been rested formally by the final pronouncement of the apex court in the country. In fact, the entire argument has been an outsourcing of the job of the Supreme Court by the various commentators since March, because whenever there is a question of constitutional disputation, the final arbiter is the highest court in the land, whose pronouncement settles the issue. So it's welcome that while the governor of Rivers that was suspended was otherwise incapacitated, 11 other state governors took the route of invoking the original jurisdiction of the Supreme Court to test the legality or constitutionality of the procedure adopted by Mr. President. There were essentially a divided opinion on both sides. Some essentially attacking the very idea of suspending constitutionally elected state functionaries, governor, deputy governor, and state house of assembly, and others who said suspension does not amount to removal, and the other question of whether there was even a basis at all, other than a made-up excuse for the federal government to intervene in the governance of Rivers State. Interestingly, this matter enjoyed a robust contest in various courts. Some of them hit the brick wall because of constitutional and jurisdictional obstacles that could not be overcome by the various entities that challenge the state of emergency, both at the state High Court and Federal High Court. Supreme Court ultimately has come down with a definitive pronouncement. So the argument no longer is whether the president could do what he did. The argument is that Supreme Court has validated that he rightfully exercised his power under Section 305 to declare a state of emergency, but they provided a number of very, very informative and insightful guardrails that underpin how that power could be exercised, because they said they would still give a considered view in order to guide future exercise of the power. Supreme Court is the only court that could do that. A high court that was not a final court or court of appeal could not. And so as a policy court, when grave question of constitutionalism arise, it is the apex court that can give a definitive verdict. And what did they say? While recognizing that the 11 governors that came did not have local standard to invoke original jurisdiction of the Supreme Court, because the three criteria for exercise of that jurisdiction were not met, which is that there must be a dispute between the state that is complaining, or the states that are complaining, and the federal government. Question of legal right or fact must be an issue, and the extent of the legal right must also be an issue. The plaintiffs in the case were unable to cross that hurdle. Nevertheless, it was a common position, which is a tribute to a credit to advocacy, competence, and professionalism of the parties that argued the case. The Attorney General of the Federation actually led the team that argued for the federal government, followed by an ex-Attorney General of the Federation in person of revered leader Chief Akinlujimi, Professor Koinshola Ajayi. My humble self was in the team, and Tayo Jegede SAN led the team for the governors. They all agreed that because of the constitutional significance of the issue at stake, even if the court concluded that the parties before them, that is the plaintiff, did not have local standard, it was still beneficial for the polity and for legal jurisprudential clarity that the court should enter upon making a clear statement about the extent of powers of Mr. President. And in summary, the court concluded that the Nigerian Section 305 state of emergency is peculiar and meant to address grave threats to peace, public order, or sovereignty of the country. And whenever that kind of situation arises, the power is vested in the president, not to exercise it arbitrarily, but subject first to follow the Constitution, two, to be guided by legislative oversight, and eventually judicial scrutiny. So it is not a matter that is not challengeable in court. Unlike some matters where they say you cannot go to court, there is a procedure to challenge the exercise of Mr. President's power of emergency in court. But the procedure is that based on a number of legislative provisions, it's so that if you want to challenge the declaration of emergency, you can only do that at the Supreme Court, not in any other court. And that was why most of the cases at the High Court failed. People did not reckon with amendment to the Supreme Court jurisdiction since the 1960s, which was modified by President Obasanjo in 1984, and also even by President Tinubu in 2005, in 2025, which clearly confirmed that you can only challenge exercise of the presidential prerogative of mercy
under Section
powers
305
by way of original action of the Supreme Court. And they said, unlike in India, Pakistan, and a few other countries, the president can indeed suspend, if it is necessary, under the test that they laid out, the test of temporariness.
Hello, can you hear me? Okay, we'll go on a break because it looks like AJ Wonikoko SAN is not hearing me. We'll sort out that audio problem, and then we'll come back to the conversation. Stay with us. We'll be right back. Welcome back to This Is Live, the Sunday talk show here on the RX News channel. Our guest is still Abiodun Jelili Owunikoko, SAN. Well, I was trying to reach out to you, but apparently you were not hearing me. I wanted to ask you, yes, the court said, okay, legislative oversight, temporal limitation, judicial review, and all of that. But Femi Falana, SAN, your brother Silk, came forward and said there was nowhere in that judgment that the 6 justices said, oh, President Tinubu or any other president, after now, has been given the powers to suspend democratic structures. And that's the main contention in Justice Obande Ogbunya's dissenting judgment. Do we have a situation here where the dissenting judgment is likely to be more compelling than the majority judgment, as we saw in Sunday Jackson against the state?
Yes, please. Hello?
Hello? Yeah, I can hear you. Go ahead.
Yes, I was waiting for the rider question. I followed the intervention reference from Mr. Femi Falana, SAN. The question you then posed, which I thought I heard correctly, was the dissenting opinion of my Lord Ogbunya, GSC. I was waiting for the rider question.
No, the question is that, do we have a situation as we had in Sunday Jackson against the state, where the minority opinion is even more important, more compelling than the majority decision, even if the majority would, in any case, have their way?
I'll say with respect that we do not have that scenario here, because you have to pose the question of proportionality. The disease determines the kind of cure that you apply to it. Where there is a breakdown of law and order involving even the instrumentality of governance at the level of a state, the sovereign authority cannot fold his hands or begin to play child's game or hide and seek with a governor who, as at that time, based on the information that was made available in the public, appeared to be the protagonist of the crisis. I do not think that the 6 members of the Supreme Court who took the same view got it wrong, and that my Lord Justice Ogbunya, who took a different view, which was a purely puritanistic point of view, is puritanistic. Look, the law, especially the Constitution, is a living document. The principle for interpretation is guided by changing circumstances. I'm not sure that I can recall, even in America, a situation where the U.S. Supreme Court ever ruled that there was no legally existing government in a state in America, as such as to allow the president to take over control of that government to restore democracy. So we are having here in Nigeria the case of Rivers, a situation whereby even the highest court had already adjudged definitively there was no legally existing government in the state. So I think it is very unlikely that a time will come where Supreme Court will pronounce against another state in Nigeria that it is not legitimate and constitutionally illegal, and the president will fold his hand and say, I can't do anything, because people who have puritanistic view of the Constitution will say, I'm usurping the power of one of the states, federating state of the country. So on the contrary, I believe that when the emotions cool down and people look at what we went through and the resultant effect of decision taken by the president, whereby even the governor today has come to even begin to appreciate the president's intervention and even decamp to his own party, it explains that we may not likely see a situation where Justice Ogbunya's view will prevail over the majority view in this case, given the same set of circumstances.
Okay, very quickly. Another thing. Their lordships, 6 of them, took a liberal and pragmatic approach, we have been told. But I would like you to speak on the issue of jurisdiction and locus standi. Because their lordships were saying these states, 11 of them, they do not have the locus standi in this particular matter. And it will be, well, I know the court of law does not speculate. It does not go on a voyage of discovery to address what it has not been asked to do in a Father Christmas manner. But having declined jurisdiction, their lordship still went ahead to address the substantive case. Isn't there a contradiction here?
Thank you. I think to answer this question, I have to make reference to a precedent. If you recall, in 2011, late General Buhari contested the election and lost, and he made it clear that he was not going to challenge that election in court. But his party went to challenge the election in court in the name of the party. And when that case got to Supreme Court held that the party did not have a locus because the candidate who was to be the beneficiary of the victory if they succeeded had already disclaimed his right to it. We have a situation in Rivers where the governor who was suspended did not go to court. Now, governors of other states went to court trying to restore him. They did not know why the governor did not go to court. So in that situation, right? I think the Supreme Court was right. Exactly. So that's why I gave you the precedent. So the Supreme Court was consistent in applying locus standi in the AG Adamawa and AG Rivers. When you look at what they did, even in a presidential election, that the party was held to have no locus standi and to be abusing process of the court by challenging an election that the candidate said he was not challenging. So in this case, you can see before the emergency was over, the so-called victim had gone to line up and queue up behind the president in his own party. So I'm sure if they knew that this was his mindset, they probably would not have bothered. They would just wait. Because what they said was that they were afraid that the Attorney General made some comments that other states who told that line will face the same consequence. And therefore, because they feared, that was why they came to court. If the Supreme Court started entertaining cases because anybody feared, then there will be a deluge. And in fact, there will be no time for the Supreme Court to handle serious cases before them. But the salutary effect of that, in this case, the pronouncement on Section 305 is not obiter. It is a definitive pronouncement of the court where they gave the reason why they had to pronounce on it, that it raises a constitutional issue of importance and there is a need for them to give clarity by dissecting the issues involved. I'm sure that what we are all debating now is a summary of judgment, which if you have seen, was not something signed by any of the judges. The real judgment will come, which will contain their full reasoned consideration. By then, it will be more appropriate to critique it. But as it were today, the law today is that if the circumstances are right, the president can declare emergency and suspend, the state government if it's necessary, subject to legislative oversight and judicial scrutiny. So once you understand this precept, I think it is clear.
Okay, SCN, I would like you to question the process. This matter took the Supreme Court 9 months for their lordships to take a decision. Now, on October 21, they said they were reserving judgment. It took them another month. And then they came forward, and then they are giving a bench judgment, or what some people call a summary judgment. Now, they delayed for so long that at the end of the day, who is benefiting from what I will call an academic reflection on Section 305? Even the original people who brought the matter before them, they had all joined APC. Even Rivers is already in APC. So what does this say about our judicial process? Is it that their lordships will just deliberately play postponing, and will it take you 9 months just to explain Section 305? Where is the problem?
Thank you very much. I believe this action was filed almost a week or two after the declaration was declared. Yes, that's almost a week. Yes, and thereafter, up until June, I believe we were exchanging processes from both sides. And as we are approaching July, the plaintiff did not appear to be pressing for an urgent hearing of that matter. If they had done so, despite the fact that vacation was creeping in July, I have no doubt in my mind that the Supreme Court would have probably reviewed their schedule, because this was a case that required a full panel of 7 don't forget, beginning of the year, they already have cases assigned to each judges, and some of them have their period of vacation or short leave. So they needed to do that. What has happened is there is a principle of what is called, there's this language the Supreme Court have used about faking an urgency. If the court considers that, given all the circumstances, it's a self-induced urgency, they will not go overboard to overburden themselves, carrying a matter that the urgency is not clear. And the urgency can only be clear by the claimant who will bring those materials before them. They, for instance, look at the case and say, look, the governor is not challenging the state of emergency. The people that challenge the state of emergency, we have already filed objection that time saying that they are busybody, they don't have locus standard. Ordinarily, the Supreme Court would have asked us to come and address them on that, and that would have ended the matter. But because they wanted to look into the merit of the case and come up with a guidance that will enrich the jurisprudence and predict what will happen in the future and guide all the parties, they took the time and they came back after July in September from vacation. The next available day they had was in October, and they had us in October. So I don't think that, given the whole circumstance of this case, that the Supreme Court had been lax. I think with all the volume of work on their table, I think they've done well. And the benefit of their having to give reason later is only constitutionally reserved for them, so that they will give a clear guidance, full address of all the issues in a judgment that will be a guide for future actions of all the protagonists and antagonists. Okay. I think they should be commended.
Okay.
Because the summary of the judgment itself is clear. You are not likely to see anything different except for a granular detail in the reason they are going to give.
Yeah. Well, maybe that will come 5 months from now, or it may never come. But we'll have the bench judgment to rely on.
No, it will normally, I can assure you that even when they reserve reason, it will not be longer than 3 months that they would normally have given their judgment. Because if they heard the matter in October, they have till January actually to deliver judgment. But they have delivered this first week, this second week in December. They still have up to January, even if they were to adjourn for judgment. They have 3 months.
Final question.
So I have a feeling that early in January, we should get the reasons from both the majority and the minority opinions.
Final question. Now, the fear of the liberal interpretation of the phrase extraordinary measures in the Constitution is that, look, this is likely to create a situation where that Section 305 can be abused. If not by President Tinubu, maybe a future president, who will say, well, the president, the judiciary, the apex court, has said you can exercise discretion. What is the limit to that discretion, regardless, without prejudice to the checks that their lordships identified?
Okay, now they've identified 2 limits. One is political, and that is legislative oversight. You know the threshold for approving an emergency declared by president within 48 hours. If it is not obtained, that emergency evaporates immediately. So actually, the Supreme Court should have been more concerned about the emergency terms as affirmed and approved by the National Assembly. Because a National Assembly not approved of it, within 48 hours when they are in session, that emergency will have automatically terminated. So politically, they've created a check. Judicially, they've also agreed that there is room for judicial scrutiny, which is why I said, when it comes to declaration of state of emergency, there is no ouster clause. It's just that there is a limited window of judicial challenge, which is that you have to go and challenge it at the Supreme Court. For good reason. If you have to challenge an emergency from High Court to Court of Appeal to Supreme Court, in fact, the matter will never end until even the president leaves office. So the lawmakers saw reason to say, if you are challenging state of emergency declaration, go straight to Supreme Court if you have a claim. Even people that are not challenging the removal of the governor, even excess of the sole administrative power, form within the ambit of what can only be challenged at the Supreme Court, within the context of what that emergency regulations and instrument has covered.
On that note, AJ Owonikuku SN, I would like to thank you very much for joining us on This Day Live, this Sunday talk show, and for helping us to clarify some of these issues. I would have loved to ask you that perhaps their lordships were not talking straight. There wasn't enough clarity But you seem to think that there was enough clarity in their submissions. Thank you very much indeed.